Okay, so let's hear it.
Okay. Yes, sir. Let me go ahead and push play.
Every story, and you should never judge a person based on one version of the story. That no matter how thin you roll a piece of paper, there's two sides to the paper. So I'm going to tell you what I have so far on the side of the story that is not in your favor. And then give you an opportunity to fill in the gaps, correct any misinformation you think we may have, and tell your side of the story. Because this will be tonight your first, last, and only chance to give us your side of the story. Because beyond here, how do you know how it works? Attorneys get involved, and then attorneys tell you not to talk. And
that's why I'm trying to talk to you. Well, because, man, that's the thing is, man, I ain't got nothing to hide. That's why, man, otherwise it would have been like, man, if I thought I needed an attorney, I would have been like, look, I need a lawyer. You know what I mean? But I know I haven't done anything, you know, so anyway, give me your side.
I'm going to let you know a couple of things. Detective picture is absolutely accurate with the timestamp on the video. We have you on video walking on 2nd Street from where you live toward Local Avenue, which is the road that the Treehouse is on. 8:11 p.m. At 8:15 p.m., the first call comes into 911 telling our dispatchers that a guy has been stabbed, he's dead, and he's laying face down in a pool of blood. Hear me out. So you have 4 minutes from where you're at to where this thing happens. Now, the really disconcerting part of all of this is at 8:19, 4 minutes after we have a report of a man being killed, we have you and Rory on video walking back from the Treehouse toward...
That's got to be impossible, though. Because, okay, you know, like I said, man, I wish I could try this because, man, again, man, go back and check the times on video. Because that had to be somewhere around the same time. Had to. You know what I'm saying? Because, man, you know, I remember, man, the whole thing with the police lights and stuff like that. It was not long after we went and got cigarettes. So, man, how could I be, man, Tom's on buying cigarettes while I'm supposed to be over there at the CVS? You know what I'm saying? Now, I do, man, like I told him, man, I have a vague memory of, man, walking through the drive-through at the CVS.
Okay.
You know, so, man, I may have gone there earlier, man, I could see that, you know, but I would know I didn't go there later. I know I didn't go there later, but, man, I may have gone there earlier. But I mean, literally check the video, man.
Okay. Now, I'm going to tell you some other things that the detective picture hasn't shared with you, that I'm going to share with you. That's on our side of the story. In the walk from Laurel Avenue on 2nd Street to where you live, we found in lot 72 a knife. Okay, on that knife is blood, and on the handle of that blood, latent DNA. That's going to the lab. Okay, and a little further up the road, in the back of a boat, parked alongside 2nd Street, is a mask. And the mask has very weird, spooky, scary face on it, but it's also made out of foam, and on the front of the mask are 3 blood smears. And the mask has a really nice elastic band that goes around the back of the head, and a nice foam pad in the front. It's loaded with DNA. Okay? Now, all that stuff's going to go to the lab.
Cool.
Okay?
I'm confident.
Okay.
Totally confident. You know?
And we have wounds on our victim that are consistent with the knife that was found in 72. So
we're trying to listen to the
know
video.
is that the story and the details of the story are not stacking up on your favor.
Well, I'm just saying, all that stuff that you just told me, test all you want.
Okay.
You're not going to find anything there for him, with anything of mine on it. You know, I mean, granted, you know, if the match came from the house, man, it might have my fingerprint on it, man. Who knows? I may have touched it. Same thing with the knife, man. I may have touched it. But I guarantee you, man, you ain't got no DNA, man, for no man on the inside of that man. And there's no man for him. I've never grabbed a knife and did anything to anybody. So Manfred, and I mean, straight up test away, because Manfred, I'm confident, man, he'll acknowledge it.
That's good. Glad to hear that.
I mean, the timestamp with the video, I mean, like I said, that one, go check.
That's all.
Okay. So I'm trying to understand the exact nature of your Ori tennis motion.
Well, Your Honor, the blood, she tells me that
Now, what is it that you're asking me to do?
I would ask this, Your Honor. I mean, because again, to be fair, and like I said, to make sure that the jury has the right information, I would either ask that the video be allowed to be back with the deliberations, or that Your Honor, instruct the jury.
Okay, so I don't see a problem, but we'll hear what the state's.
But there is no inconsistency here. What we argued is genuine. We argued that he wouldn't know it's Matt Bonnett's blood on the knife. They simply identified the evidence that they have. He deduced that it was Matt Bonnett's blood and told Paulo Belmonte. This video is not evidence. We haven't contradicted anything in evidence. We made argument. So I would submit to the court, there's nothing here to rule on other than nothing, really.
Your Honor, if I might. No, they said this was their single most compelling piece of evidence, that there was no way I could have known.
Okay, stop
And yes,
it. Get to the point that somehow or other they were misrepresenting the state of affairs because they knew that someone had told you that it was Matt Bonnett's blood and they intentionally misrepresented that? Is that what you're claiming?
Yes, I am saying that, Your
Well,
Honor.
that video doesn't establish that.
Your Honor, I definitely could infer from what she just told me that was Matthew Bonnett's blood. If it's consistent with the knife wounds, if again they have blood on the knife, then it only stands to reason that it's Matthew Bonnett's blood. Again, they're purporting that conversation to be something that is totally evident that I had to be there. And they said there was no possible way for me to know. Well, yes, there is.
Okay, thank you. I'm denying the motion. I find that the information conveyed to the defendant during the Penny Phelps interview is not inconsistent with the state's argument. There was mention of blood found. It was, in fact, I believe there was indication it was going to be sent for testing, but it was never told to you, oh, that's Matt Bonnet, that's Matt's blood. It was not. So anyway, Mr. Tucker, I've made my decision. I recollect that, no, sir, I'm not going to argue any further. I've heard your motion. I've made my decision. I allowed you to, when the state objected during closings, you're right, they can't use something as a sword and a shield. That didn't come in because of the interview, the statement, because it's a prior consistent statement, basically, that's inadmissible. But when they objected and you started to talk about this particular interview, I overruled the objection and said that you could mention that you were at the station for a long period of time and questioned about the event. So I allowed you to make some explanation. I didn't allow you to go into what was said. But yes, sir, you haven't.
I'm not trying to argue with
Well,
you.
that's what you're doing. If you had a question about my ruling, that's fine. But
I do, Your Honor.
okay.
I'm not trying to argue with you.
Wilson, what's your question?
Your Honor, yes, I know that Your Honor overruled their objection.
Right.
You did establish that I could talk about being at the station. I could not talk about what the hearsay would have been if what I was told. And I really do think, Your Honor, it is very, very, misleading to the jury to allow them to go back there and deliberate on something that could cost me my life based on, information that, again, they're not being provided the entire amount of information concerning what the major part of their case is.
Okay. I understand your position. I've denied the Ori Tennis motion for finding no violation, allowed the video to be played in the record, allowed the Ori Tennis motion, heard substantial argument, made a decision, provided rationale to support the decision. understand you disagree with it, understand you've preserved the issue should it become necessary, but in any
I'll go
event.
ahead and take the video off of it, yeah.
Okay, I don't mind. I saw Kerry in here. Did he want to come in here, or could we ask Deputy Riccio if Riccio's there? Because I saw Kerry and there was some question about the operation. I saw him come in here earlier. I assume he wanted to check something.
He's going to turn the internet off on the TV so we can go back if there's
It's unbelievable. The AC has to be malfunctioning. It's unbelievable. I don't know. I'm gonna go check with court administration while Kerry's doing this. I'll be right back. You know. Okay, do we have all the jurors present?
Your Honor, the only remaining, I guess, issue is the unbolded
Oh,
3.10. It's really up to the defendant and the court. I just did it in.
well, it's fine. It's with me. We mentioned the.
No, as long as, as long as it's the same
Yeah,
document.
it's the same one here. Same documents.
Which number is it?
3.10.
Yes.
And what's copied yesterday, it was bolded. I just unbolded it.
Well, this is the one I have.
Same package.
I don't need a whole new package. I already got this one completely organized. I think. Well, let me look. That's
Oh, sorry,
that's
just-
a different instruction.
Handed up the wrong one.
0.10.
I apologize.
Okay, that is in lighter type, consistent with the type of the other instructions, so I'll substitute the one that's darker for the one that's lighter. It says the same thing. Thank you. Let's bring the jury in, please. Thank you. Please be seated, everyone. Good morning. Good to see you all here again this morning, members of the jury. So, yesterday you heard closing arguments. And I told you that in light of the hour and the like, that it seemed to me to make more sense to send you home for the evening, to take care of the business that we needed to take care of, and to have you come back this morning so you could receive jury instructions and have ample time for your deliberations. And so here we are to do that. So I'm going to now instruct you on the law applicable to the case. I'm going to use this packet of written instructions, basically verbatim. When you go back to deliberate, along with the evidence, you're going to have this packet of instructions, exactly what I'm using to instruct you. So you'll have both the verbal instructions and the written package. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Franklin Tyrone Tucker has the right to be represented by an attorney or to represent himself in this trial, as do all criminal defendants in this country. He has exercised his constitutional right to act as his own attorney. This decision should not affect your consideration of this case. Franklin Tyrone Tucker, the defendant in this case, has been accused of the crime of first-degree felony murder, robbery with a deadly weapon while masked, aggravated assault while masked, and battery while masked. If the defendant helped another person or persons attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt, number one, the defendant intended the crime to occur, and number two, the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. To be a principal, the defendant does not have to be present when the crime is committed or attempted. For first-degree felony murder and second-degree murder, it is not necessary for the state to prove the defendant intended the death of Matthew Bonnett. It is not necessary for a principal to know every detail of how a first-degree felony murder, second-degree murder, robbery, aggravated assault, or battery will be committed, as long as the principal intended the first-degree felony murder, second-degree murder, robbery, aggravated assault, battery to occur, and did some act or said something that was intended to help and did help the first-degree felony murder, second-degree murder, robbery, aggravated assault, battery to occur. To be found guilty of a first-degree felony murder, second-degree murder, robbery, aggravated assault, battery, as a principal, it is not necessary for the state to prove a defendant knew another participant of the first-degree felony murder, second-degree murder, robbery, aggravated assault, or battery while armed. Franklin Tyrone Tucker is accused of first-degree felony murder in count 1 of the indictment. First-degree murder includes the lesser crimes of second-degree murder, manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Matthew Bonnett was killed by Franklin Tyrone Tucker, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree felony murder or second-degree murder, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. Number 1, when the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and in misfortune in the heat of passion upon any sudden and sufficient provocation, or when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Franklin Tyrone Tucker may be found guilty of first-degree felony murder or any lesser included crime. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. Number one, Matthew Reed Bonnett is dead. Number two, while engaged in the commission of a robbery, Franklin Tyrone Tucker caused the death of Matthew Reed Bonnett. Number three, Tyrone Tucker was the person who actually killed Matthew Reed Bonnett, or Matthew Reed Bonnett was killed by a person other than Franklin Tyrone Tucker, but both Franklin Tyrone Tucker and the person who killed Matthew Reed Bonnett were principals in the commission of robbery. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. To prove the crime of robbery, the state must prove the following four elements beyond a reasonable doubt. Number one, Franklin Tyrone Tucker and or his accomplices took the money or backpack from the person or custody of Paula Belmont. Number two, force, violence, assault, or putting in fear was used in the course of the taking. Number three, the property taken was of some value. And number four, the taking was with the intent to permanently or temporarily deprive Paula Belmont of her right to the property or any benefit from it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim, when it appears the person making the threat has the ability to carry out the threat and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear, and actual fear on the part of a victim need not be shown. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist in any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of a victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if, in the course of committing the robbery, the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find that the defendant and or his accomplice carried a knife in the course of committing the robbery and that the knife was a deadly weapon, you should find him guilty of robbery with a deadly weapon. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that the defendant carried a weapon that was not a firearm or a deadly weapon in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may be a weapon if it was used or threatened to be used or intended to be used in a manner likely to cause bodily harm. Counts 1 and 2 are linked in that the crime charged in count 2, robbery, is an essential element of the crime charged in count 1 of the indictment, first-degree felony murder. You should first consider the evidence applicable to count 2. If you find the crime in count 2 has not been proven beyond a reasonable doubt, you must find the defendant not guilty on both counts 1 and 2. If, on the other hand, you find that the crime charged in count 2 has been proven beyond a reasonable doubt, you must then consider the evidence applicable to count 1. A guilty verdict on count 2 does not require a guilty verdict on count 1. You should find the defendant guilty on count 1 only if you find all the elements of that crime, including the essential elements contained in count 2, were proven beyond a reasonable doubt. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of first-degree felony murder is second-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. Number 1, Matthew Reed Bonnett is dead. Number 2, the death was caused by the criminal act of Franklin Tyrone Tucker. Number 3, there was an unlawful killing of Matthew Reed Bonnett by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, number 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and number 2, is done from ill will, hatred, spite, or an evil intent, and number 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Excuse me. To prove the crime of robbery, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, Franklin Tyrone Tucker and or his accomplices took the money or backpack from the person or custody of Paula Belmont. Number 2, force, violence, assault, or putting in fear was used in the course of the taking. Number 3, the property taken was of some value, and number 4, the taking was with the intent to permanently or temporarily deprive Paula Belmont of her right to the property or any benefit from it. An assault is an intentional and unlawful threat, either by word or act, to do violence to a victim when it appears the person making the threat has the ability to carry out the threat, and the act creates in the mind of that victim a well-founded fear that violence is about to take place. If the circumstances were such as to ordinarily induce fear in the mind of a reasonable person, then a victim may be found to have been in fear. An actual fear on the part of a victim need not be shown. The taking must be by the use of force or violence so as to overcome the resistance of a person, or by putting a person in fear so that he or she does not resist. The law does not require the force, violence, assault, or putting in fear to be exerted against the victim from whom the property was taken if the force, violence, assault, or putting in fear was exerted against another in the course of the taking. The law does not require that a victim of robbery resist to any particular extent, or that a victim offer any actual physical resistance if the circumstances are such that a victim is placed in fear of death or great bodily harm if he or she does resist. But unless prevented by fear, there must be some resistance to make the taking one done by force or violence. In order for a taking by force, violence, or putting in fear to be robbery, it is not necessary that the taking be from the person of a victim. It is sufficient if the property taken is under the custody of the victim so that it cannot be taken without the use of force, violence, or intimidation directed against the victim. If you find the defendant guilty of the crime of robbery, you must further determine beyond a reasonable doubt if in the course of committing the robbery the defendant carried some kind of weapon. An act is in the course of committing the robbery if it occurs in an attempt to commit robbery or in flight after the attempt or commission. If you find that the defendant and or his accomplice carried a knife in the course of committing the robbery and that knife was a deadly weapon, you should find him guilty of robbery with a deadly weapon. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that the defendant carried a weapon that was not a firearm or a deadly weapon in the course of committing the robbery, you should find him guilty of robbery with a weapon. A weapon is any object other than a firearm that will likely cause bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may be a weapon if it was used or threatened to be used or intended to be used in a manner likely to cause bodily harm. If you find that Franklin Tyrone Tucker committed robbery, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried a knife, you should find him guilty of robbery with a weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used or threatened to be used or attempted to be used or intended to be used to inflict bodily harm. If you find that Franklin Tyrone Tucker committed robbery, but you are not convinced beyond a reasonable doubt that he personally carried a weapon, then you should find him guilty only of robbery. To prove the crime of aggravated assault, the state must prove the following 4 elements beyond a reasonable doubt. The first 3 elements define assault. Number 1, Franklin Tyrone Tucker intentionally and unlawfully threatened, either by word or act, to do violence to Roger Allen Roggett. At the time, Franklin Tyrone Tucker appeared to have the ability to carry out the threat. Number 3, the act of Franklin Tyrone Tucker created in the mind of Roger Allen Roggett a well-founded fear that violence was about to take place. And number 4, the assault was made with a deadly weapon. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Roger Allen Roggett may be found to have been in fear. An actual fear on the part of Roger Allen Roggett need not be shown. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a deadly weapon if it was used or threatened to be used in a manner likely to cause death or great bodily harm. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. Franklin Tyrone Tucker actually and intentionally touched or struck Roger Allen Roggett against his will. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. If you find that Franklin Tyrone Tucker committed crimes charged, you also find beyond a reasonable doubt that Franklin Tyrone Tucker was personally wearing a hood, mask, or other device that concealed his identity, you should find Franklin Tyrone Tucker guilty of crimes charged while wearing a device that concealed his identity. If you find that Franklin Tyrone Tucker committed the crimes charged, but you are not convinced beyond a reasonable doubt that he personally wore a hood, mask, or other device that concealed his identity, then you should find the defendant guilty only of the crimes charged. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment and information for each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged with committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to say and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you applied to the testimony of the other witnesses. It's entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of a witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accordance with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding the verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged, or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. As I explained, the evidence goes back, the written instructions go back, and these verdict forms go back. And I'm going to go over them verbatim right now as part of my instructions. They're not complicated. You should find them quite self-explanatory, but again, to be thorough, I'm going to take a moment here to review them. There's 4 separate verdict forms appropriately labeled to correspond with each of the 4 counts. So I'm going to start with verdict count 1, and you can see in big bold letters, there it is, identified as verdict form for count 1. In the upper left corner is the date line. When the jury has reached its verdict, the foreperson should put today's date, that's when you reach your verdict, which is January 25th, 2024. Right below the date line is the jurisdictional statement in the Circuit Court of the 16th Judicial Circuit in and for Monroe County, Florida Criminal Division. You will remember way back to jury qualifications, and we talked about everybody being a resident of the 16th Circuit, because in order to be a juror, you got to reside in a jurisdiction wherein the crimes were allegedly occurred and where the trial is taking place. So this tells us what the jurisdiction is. And then right below the jurisdictional information on the left is what we call the style of the case. State of Florida Plaintiff versus Franklin Tyrone Tucker Defendant, case number 2017 CF 841CK. You've heard me say that multiple times. That's the case style and the case number. And below that is the heading of the form, and then there's 3 choices here. If the jury's verdict is we, the jury, find the defendant guilty as charged in the indictment of the offense of first-degree felony murder, the foreperson puts a check mark in the line ahead of that verdict, and then you see down here in the lower right is an area that says, so say we all, a line, foreperson. That's where your foreperson signs and then dates the verdict form. If the jury's verdict as to count 1 is we, the jury, find the defendant guilty of a lesser included offense of second-degree murder, well, then the check mark goes on that line. And then once again, signed and dated by your foreperson. And as to count 1, if the jury's verdict is we, the jury, find the defendant not guilty, then the check mark goes on that line and once again signed and dated in the appropriate place. We've got a separate verdict form for count 2. This one's 2 pages. It's the same format, and I'm not, it's got the same information above the heading, and again, it's verdict count 2. So, if as to count 2, the jury's verdict is we, the jury, find the defendant guilty as charged in information of the offense of robbery, then the line ahead of that verdict is checked, and then the jury considers the questions or interrogatories if it's guilty as to robbery. Obviously, if you don't find the defendant guilty of robbery, you don't go to these questions, but I'm going through the form in chronological order, not by any means suggesting what your decision will be, but only explaining it as it's presented here. So we see some instructions. If you find the defendant guilty of robbery, you must then answer the following questions. First question, in the course of committing the robbery, was Franklin Tyrone Tucker in possession of a deadly weapon? One of two answers, yes or no. Whatever the answer is, if you get to that part, that's where the check mark goes. Yes in front of yes, no in front of no. And you go on to the next question. In the course of committing the robbery, was Franklin Tyrone Tucker in possession of a weapon? If you get to this interrogatory, once again, yes or no, lines ahead of both choices. Whatever the decision is of the jury, that's where the check mark is placed. And then the final interrogatory on the second page, in the course of committing the robbery, was Franklin Tyrone Tucker wearing a mask? Same choices, yes or no, check mark in front of that answer that the jury unanimously finds to be proven beyond a reasonable doubt. So, if the jury's verdict was guilty and as to robbery, and you get through all those interrogatories, then the foreperson, again, this time it's on the second page, but it's again in the right-hand bottom part, signs and dates the verdict form. Now, if the jury's verdict as to count 2 is we, the jury, find the defendant not guilty, so then there's where the check mark goes. You don't get those interrogatories, and you just have the foreperson sign and date the verdict form. That's count 2. Count 3, separate verdict form, so labeled. Same format at the upper portion. Again, heading clearly says count 3. And then we look at the choices that the jury, the decisions available to the jury. If it is, as to count 3, we, the jury, find the defendant guilty as charged in the information of aggravated assault, the offense of aggravated assault, that's where the check mark goes. And then you look at the instructions immediately below that finding, and you're told if you find the defendant guilty of aggravated assault, you must then answer the following questions. It's actually only one question. In the course of committing the aggravated assault, was Franklin Tyrone Tucker wearing a mask? Once again, there's yes or no options, lines in front of each one. If you get to this interrogatory, you check which one of those two options the foreperson does. The jury so finds, signs, dates the verdict form by the foreperson. As to count 3, if the jury verdict is we, the jury, find the defendant not guilty, then the check mark goes in front of that verdict and signed and dated by the foreperson. Separate verdict form for count 4, same heading, label, count 4. If, as to count 4, the jury's verdict is we, the jury, find the defendant guilty as charged in the information of the offense of battery, that's where the check mark goes, ahead of that verdict. And then following the instructions, if you find the defendant guilty of battery, you must then answer the following question. In the course of committing the battery, was Franklin Tyrone Tucker wearing a mask? Yes or no? Check the line in front of the answer that you find if you get to this interrogatory. As to count 4, if the jury's verdict is we, the jury, find the defendant not guilty, there's the line ahead of that verdict that's checked. And once again, when you complete the verdict decisions as to count 4, so say we all, signed by the foreperson, dated on the date. A separate crime is charged in each count of the indictment and information, and although they may have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged, except as explained in the instruction for legally interlocking counts. In a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. And I'm going to explain a little bit more about how we handle that provision here in the 16th Circuit in just a moment. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent into the jury room with you when you begin to deliberate. And that includes this unit here. That's going to go back. Its operation is fairly straightforward, so if you care to view any of the video evidence, you'll be able to do so. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So I'm going to ask attorneys to approach the bench. Let me see this a second, please. Remember back in jury selection when we talked about alternate jurors? We heard from a couple of folks who served in alternate jurors, and I explained, I believe at that time, the importance of alternates and how I didn't relish by any means excusing alternate jurors because, as has been the case in this particular case, our alternates have been here throughout, just as attentive and patient and involved as the first 12, and now I have to excuse you because the first 12 jurors have been here throughout and are now ready to deliberate, and the law doesn't allow any more than 12. So one might ask, well, why were we here, Judge? I mean, goodness gracious, we've listened all this time. We'd like to share our thoughts now that we've spent all this time here. We'd like to hear what the others think, and you're denying me the opportunity. I understand that feeling entirely. All I can tell you is that more often than not, in trials, especially one of this duration with this number of jurors, things happen where one or more of the first 12 are unable to complete the case. If we don't have an alternate to sit in that very seat that's been vacated, we have a mistrial. And you already heard instructions about how a mistrial is a waste of time and inconvenience on a cost and all the above. So we try to avoid that by having alternates. In this case, we haven't needed them. So with my sincere thanks, I'm going to excuse Ms. Van Stry and Mr. Amsterdam. But thank you very much. I certainly appreciate your service and your involvement. So just a couple other things. I'm going to give those folks a moment to clear the jury room. Just give a few further explanations about some of those instructions. I mentioned about electronic devices. You've heard lots of instructions about the prohibition about electronic devices, and it makes sense. In terms of the prohibition against having access to the electronic devices, the personal devices, that's an administrative order from the Florida Supreme Court. That's not something that yours truly has concocted on his own. That comes from the Florida Supreme Court, and of course we honor their authority and their rules and regulations. But here, instead of having you leave whatever devices are on the seats there, we have what's called a lock box in the jury room. So you bring them in there, bailiff will be in there at that time, present whatever electronic devices you may have. Right before your very eyes, they're placed in the lockbox, it's secured, there it sits. So I think that gives people a little bit more security and assurance that their devices aren't going to be compromised. Not that they would be, but just in terms of state of mind, they're right there, and when you're finished, they're there for you to repossess, to take again. So that's how we do that. You will be able to take your notepads with you now. If there is some question, problem, communication that you believe is needed with the court, then your foreperson should take a clean page, nothing with any kind of marks on it, but a clean page, and in legible, complete, comprehensible fashion, write or print whatever it is you want to ask me or tell me. Judge Jones. Then, when it's complete, the foreperson should put his or her name, fold it in half, knock on the door, give it to the bailiff. The bailiff will alert me, give it to me. I'll look at it. I'll share it with everyone, the lawyers, and I will do my best after receiving input from them to provide an appropriate answer. So, the alternates gone. Ladies, gentlemen of the jury, you may now retire to consider your verdicts. Okay, so when Deputy Riccio comes out here after securing the electronic devices, I'm going to give him the verdict forms, the instructions. Then I'm going to have him, or one of the security officers, take all the evidence, bring it back, knock on the door, present it along with this device to view it. So what I would ask the clerk to assemble it, which you probably already have, but when I step down here, if Mr. Tucker and the state wants to examine the accumulation of evidence, just to be sure that it's complete before it goes back, that everything that's supposed to be there is there, and similarly, everything, if there's anything that's there that shouldn't be there, then it doesn't go back. I doubt if either one of those is the case, but just to be sure. Then, as we mentioned yesterday, you all don't have to stay here if you care not to, as long as there's a means to contact you telephonically and you're able to return in the event of a question, a problem, a verdict in 5-10 minutes. I also mentioned that just as soon as we finish our immediate business, I have another docket that I'm going to be conducting, and of course, anytime I'm needed in the trial, that docket will be halted and we'll address the trial. So, here are the instructions and the verdict form. They can look at that too. The warranty, and then actually the evidence to take back. So, at this point, I'll stand in recess awaiting for. Thank you. I'll be.
All right, so court is now in recess. Jury is deliberating. However, before we go in recess, at least for deliberations, I wanted to just play back one section of the judge's instructions, because I think that it's relevant to understand. This is the most important section of a judge's instructions when they're considering a verdict. And when you listen to this, I want you to listen to it again, because, if you listen to this and you consider that this is what they're having to consider, this explains how they're supposed to deliberate, and it's going to explain why this is going to be a really quick verdict for not guilty, in my opinion, or maybe there's one or two people back in that jury room that are going to need a little prodding to get across to not guilty. So, it might take an hour or two, but ultimately this is going to be a not guilty verdict. So let's go back into the courtroom and just re-listen to this one small portion here that I think is really relevant to the deliberations. So let's talk about this here. Let me hit play.
You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accordance with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions.
And that's an important, especially if you go into some of these chats that are out there, that is a very, very important instruction from the judge. And that is this. You cannot allow any bias to come in. You got to judge it from the evidence. If the police would have done that, if Detective Malone would have followed that and understood that and never made a judgment on a Facebook photo, he wouldn't be here. This instruction right here, hopefully the jury's listening very closely to that and understands, hey, listen, you cannot allow personal bias. You can't allow, and again, those are all the things that the state tried to inflame here. They tried to suggest he was trying to influence Paul's testimony without any evidence of that. They tried to say that his wife was trying to buy people's testimony off. They tried to say he was essentially, a bad guy. They tried to make fun of the fact that he was raising questions about their investigation. Obviously, they tried to make light in front of the jury of the fact that he was trying to represent himself, and they want the jury to be frustrated with him. Again, none of it's evidence, but it's their attempt to try to cover up the fact or get around the fact that they don't have any evidence. They have nothing. They have Travis Johnson. You're going to hear the key instruction here that annihilates Travis Johnson. Let's continue listening.
Deciding the verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. As I explained, the evidence goes back, the written instructions go back, witness to testify of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged with committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reason.
Now, obviously, in Christine Fleming, I absolutely agree. Yes, that's the scary part about this, is there are juries that have convicted on less. However, what we have to hope is, in this case, is that the jury has been observant, that the jury has been able to see that Franklin Tucker, the different things that he was able to get across to the jury, get through to the jury, and that the jury's, I think, one of the keys here that I think really might stand out to an observant juror is the use of the word vacillate, right? And Travis Tucker, or Travis Johnson, used that in his testimony. And I think that alone tells you, is kind of a giveaway. And an observant juror may recognize the fact that a lot of attention was brought to that word, and Travis Johnson's use of that word, indicating exactly what Tyrone Tucker was arguing to the jury, that the state manufactured Travis Johnson's testimony. And when you hear that pop up in a jury instruction, and you hear that this witness is using that on the witness stand, he gets it from one person, the prosecutor, or from one place, the prosecutors. Now let's continue listening a little bit more here on this instruction, because we're getting to the good part here in just a second.
Reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are,
And this is it right here.
witness seemed to have an opportunity to say and know the things about which the witness testified. Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify?
All right, so the answers to those three questions right there, those three criteria, okay, when you analyze Travis Johnson's testimony, essentially, without a doubt, gives basis for the jury to disregard his testimony. Was he given some sort of preference? Absolutely. Did his testimony differ or conflict with other testimony? Absolutely. Those two alone are enough for the jury to say, we disagree. You take away Travis Johnson's testimony, and of course you come to a position where there's no evidence. And the jury's not allowed to speculate. They're not allowed to infer. They're not allowed to sit here and say, well, we think this could have happened or that could have happened. They've got to rely on the evidence and record. And that's all there is. They're certainly not allowed to go and say, well, there's an inconclusive DNA result. We think that means something. It doesn't mean anything. They have to assume that when it's inconclusive, it breaks to the favor of the defendant. Now, we're listening a little bit more.
Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony?
Now, those two, one of which, obviously, the jury knows he was convicted of a felony. Okay, so we check another box off. However, the inconsistent statement, this is why Mr. Tucker needed to get in and wanted to get in the suppression motion. Had that been in, the jury would have been able to have considered that as evidence of a statement he made that wasn't consistent with what he testified to. And of course, this statement is significant because it's filed on his behalf in front of the court. Now, while it's not a sworn statement, it was essentially given to an officer of the court who believed it, and a sworn officer of the court who says, I can't present something I knowingly or believe is a lie. And that statement would have been able to have been before this jury as something for them to consider when considering Travis Johnson's testimony. You see why it was so important, and you see why the state fought so hard to keep it out. It did pretty much anything, and why the judge on Monday immediately in what appeared to almost be a almost organized event where the judge just swooped in and went right after Tucker for the alleged delays, and knowing he had subpoena issues, knowing that on Monday, okay, if you go back to day one, state didn't have any more witnesses. They ended early. The judge was very frustrated. Day two, okay, is they go all day because Malone's testifying. Day three, the state doesn't have any witnesses because they allege, well, we thought the cross-examination was going to continue throughout the afternoon. Okay. Had the state had witnesses on Monday, like they should have, okay, and on Wednesday, like they should have, no subpoenas expire. Tucker's probably presenting his case by Thursday, and all those witnesses would have been at the courtroom or at the courthouse, and there would have been no issue with any of those things. But Friday, and again, a lot of people were hard on him about that, but nobody considered Monday. That was not Tucker's fault when he didn't have any witnesses. That was the state's fault. They ended early. Go back and look at the tape. Go back and look at how much was done. And the judge at the end of the day says, well, there's no witnesses. I'm sorry, ladies and gentlemen of the jury, it's a short day. Because the state didn't estimate. They did. They knew what they were doing. They were playing games this entire time. And individuals who aren't paying attention or aren't looking, might not understand what they're seeing. But what was happening there, without people understanding how this was going to play out, was it was meant to disrupt Mr. Tucker. And what you have to understand, you might say, well, it's his job to have his subpoenas ready to go and things of that nature. What they were taking advantage of was he was a one-man show, because normally an attorney would have somebody down there, a clerk or a secretary, filing those subpoenas while he's in court. He couldn't do that. And by the time he realized that he needed to do this, he's in court, so he's having to take care of it on a break. He comes back in. He's fully expecting, as the judge had been up until that moment, very amenable to helping, guide him through these things. And then the judge just lowers the boom, kills the rest of his case, and keeps this suppression motion out. And that's why he wanted to keep it out, because they knew when that comes in, and all the other things that you could say about Travis Johnson's testimony that are true, there is no way this jury has even a chance of convicting. In fact, he might have had to give the judgment of acquittal, which he would have never wanted to do, because that would require him, a member of the justice system in Monroe County, would have had to say, yes, state, you don't have the evidence. And he didn't want to do that. He didn't want to do that. Let's finish watching this section.
Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider that.
All right, so Christine Fleming, isn't strategy part of a lawyer's done? Just because there's no substantial evidence doesn't mean he didn't do it. That's not that is you and I having a discussion. We can have that discussion and say, well, just because this, that. That's not the standard in a court. Remember, a trial is truly not, and this is something that a lot of people don't understand this, stand about a trial. In fact, as hard as it's for people to understand, a trial is not actually about guilt or whether or not proving whether someone did it or didn't do it. Okay. That's not it. What it's about is whether or not the state goes, the process, the way this process works, the state police investigate, they present their findings to the prosecuting attorney or to a judge, they get a warrant, they bring someone in and they say, you're going to answer to charges. The state reviews the investigation. They can hold that defendant for a period of time before they have to let them have bond and get out, or maybe even dismiss altogether. State makes a finding and says, hey, we believe there's evidence here. We believe that there's proof beyond a reasonable doubt here, that we can prove each and every element. They're going to look at the law books because, again, the reason why the police aren't making that determination is because we take our lawyers and make them go to law school, and they have to apply the law to the facts of the case. So a skilled prosecuting attorney should be fairly applying the facts of the case to the law. And then they say, these are the crimes we believe were committed. They take that, they make a presentation at the initial appearance, and then the defendant is afforded three options. If they qualify, they can get a public defender to help them, guide them through this process, why they get to review and question the case. They can represent themselves, as Mr. Tucker did, or they can hire an attorney. At that point, hearings are going to be set, and pretrial hearings, as much as people want to say, are about finding loopholes and things. It's not about finding a loophole. It's about it's about making sure that the evidence that the state is going to present to prove their case is valid and allowed to be presented against the defendant in the case. It's a review process to say, before we put this before a jury, we've got to make sure that the evidence was collected in a valid way, that it meets all the standards and laws in the state, if it's federal, in the federal justice system. And it's a process that, again, you want to have a skilled attorney on your side, because they're going to understand the nuances. They're going to understand the different ways this is evaluated. One being through rulings by other judges, which is one of the benefits of having an attorney, because they can go find case law. So as a result, that goes on. When it gets to trial, by the time you get to trial, that's why a lawyer will tell you most trials are determined by what the judge's rulings are prior to the trial ever happening, because the evidence that's allowed to come in or isn't. And in this case, you couldn't say case it's sure, because all the evidence was, a majority of the evidence that the state didn't want in was kept out. Some of it, most of it, a lot of it should have been able to come in for the jury to consider, so they could consider the entire record of the investigation and everything that happened. That's the only reason why the state is even sitting in the position where they have a case before a jury, because a majority of the things that should have been considered about this investigation, which is very important when they're reviewing the entirety of everything, all the witnesses, all the eyewitnesses, everything you would want to have in a case like this, the state was able to get it thrown out. That's the frustration Mr. Tucker says is going on, because judges were basically ignoring the law. It's why when he filed his motion to dismiss and he said there were due process issues and there were things that were happening, there is a huge record of things that happened that if this jury knew about, knew how the investigation was conducted, knew about the character and the credibility of these investigators and things that were found, this jury would be absolutely, it would be a slam dunk not guilty. And that's why when the judge said in open court and said, it's not about the investigation, it's about the evidence emanating, that's a new standard that he created from the bench in order to get this case, to allow this case to go to the jury and keep certain things out, keep that IA report out. A good attorney in the courtroom would never have allowed the judge to say that, and would have absolutely said, what are you talking about? The trial is all about the investigation. The investigation is being reviewed and being questioned, and the defense is absolutely allowed to raise any questions that emanate from that investigation or the parties of that investigation. Now, anyways, but once it goes to trial, the trial is not about an investigation of finding, and which is one of the reasons that one of the things that frustrates me when you hear commentators on TV say it's a search for justice. No, the search for justice happened in the investigation, happens in the lead up, happens in the pretrial. The trial is just a review. It's when 12 members of our society, 12 members of the community get to come in, and they get to see, the state gets to say, this is our evidence that we believe proves these elements. The state's case isn't supposed to be about standing up and using manipulative tactics and doing the things you saw happen in this case, where they're twisting and turning evidence. It's supposed to be a straightforward presentation. This is the evidence. This is how we believe it meets each and every element of the crime. And then the defense gets to raise questions during that process. They get to ask questions, raise questions. And when the evidence is being looked at, it's being looked at and starts from a point of innocence. And this is very important, because any other criminal justice system requires the defendant to disprove a negative. In other words, they've been accused. Now they have the burden to prove themselves innocent or that they didn't do it. In our justice system, the unique part about it, the thing that makes us special, is when we come in, because they recognize the difference between the state and all the money that the state has and resources that the state has, to balance that, the defendant gets the presumption of innocence, which is a very powerful thing if applied correctly to a case. That is that when the jury starts its review of this case, they review and assume that the defendant is innocent, and that it is the state's job to prove beyond a reasonable doubt. And a reasonable doubt is simply this: well, I think he could have done it, or I think he did this, but I'm still not sure. And that's the standard that they are supposed to say, that we have said in our society, that says we're not going to let anybody go to jail, lose their life, liberty, and happiness if we're not sure, if we're not beyond a reasonable doubt. If 12 jurors can't come into a room and without Paul's hesitation, vacillation, or wavering, say, yes, this person is guilty and all the elements of this crime are met. If that's, and prosecutors hate that. And it's why they spend resources and seminars and trainings to try to figure out how can they obfuscate and get around that. It's why, again, many people go and as like some of you might watch Bruce Rivers, some of you they self-snitch, right? And he makes a big deal. I love his show, I love his channel, because he talks about the fact that people go snitch on themselves because a lot of people don't understand that they don't have to talk to the police, or they feel obligated to talk to the police, and they don't understand that the police have gone to trainings and seminars and spent hours and hours trying to trick you into getting around the Fourth Amendment, because the biggest, most frustrating thing for them is the fact that you don't have to talk to them. They can't make you talk to them. So when you're accused of a crime, and the reason and the basis for that comes out of the fact that, again, you're presumed innocent at every stage of this process. But when you're in a trial, it is not about this, proving, or it's not this journey to say we're actively investigating and we're searching for justice. No, it's not a search for justice. It's a review of the state's case. The prosecutor calls it a search for justice because that's what they want the public to think, that there's that justice is something we're searching for. It's an outcome. It's what we say it is. No, justice is the process, that entire process I just described to you. And it's the process of reviewing. Again, part of that process is the trial and reviewing it. Now, once the trial happens and the jury makes their decision and says, basically, we find you guilty, we find that the state proved their case, or we find you not guilty, the state didn't prove your case. If it's not guilty, the process stops. And for purposes of that case, the justice has been served, whether you like the outcome or not. Justice has been served because the process went through, and the only barometer of that is, was it fair? And if at some point you could say that it wasn't fair, or something was done, then obviously there should be further action taken. That would be whatever civil or criminal action that would come out of that. If it was a not guilty verdict, it's the only remedy you would have, because you're not going to be able to try to defend it again, because a not guilty verdict is final. There is no going back. But a guilty verdict now leads to an appeal, and many people get upset. I get an appeal lawyer, he'll get off. No, the appeal, again, is a separate review. We should all welcome this, because now the entire proceedings that were happening below gets reviewed now by judges who go and say, was the law followed? Was procedure followed? Some courts have one level of appeal, some have multiple. The federal level has, the circuits, and then from this, you've got the circuit level of appeal, and then it goes all the way up to the Supreme Court. State of West Virginia, it's circuit court, and then circuit courts where you have your felony trials, magistrate courts where you have your misdemeanor trials. But if you have a misdemeanor trial, circuit court will review that, then the Supreme Court. But if you get convicted on a felony, you're going to circuit court for the trial, and then it's only one way it's going to go, and that is to the Supreme Court. But what's happening next is extremely important, because what you're going to do is you're going to have an appellate attorney review the record of the case to make sure. And 99 out of 100 times, they're going to find a few things. They're going to raise those issues, and it's going to go nowhere. But there are times that we find there are problems, and then it goes to the Supreme Court to review. Now, once the Supreme Court has reviewed and affirmed, a case, or denied to hear a case, at that particular point, the justice process has, for all practical purposes, ended. Now, there are some things that can still go on, like a habeas corpus that can go on, where they can file a habeas if there's things like ineffective assistance of counsel, if there's new evidence that comes to light. There are remedies, but for the most part now, the process continues with the serving of the sentence of whatever it was. Now, when the person serves their sentence, does their supervised release, that's when the justice process ends. That's when justice has been served. Now, to answer the question here, why did he go pro se? I believe the reason why he went pro se, okay, was because he wanted to get before the jury. He wanted to put himself before the jury in terms of what he was hoping. Now, again, the case he wanted to present didn't get presented. But I believe he believed if he would have put Todd O'Quinn on the stand, and you can go back on this channel, you can go over to his channel where he has a lot of the video statements and things up. Todd O'Quinn very, 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 talks about what he sees, who he sees that second person being, and he was going to give the jury the opportunity. Paula talks about how she heard a statement made. I think he wanted to get his voice in front of the jury. He wanted to get who he was in front of the jury, and most importantly, I think he wanted to be able to tell his story, how he wanted to tell his story, because he was frustrated with the fact that essentially he had his attorneys for all of the important evidentiary hearings and things, but when all of the evidence was being not admitted, right? An attorney is subject to the bar, right? They're subject to the rules of professional conduct. So if his attorney would have stood up there and talked about things that couldn't be talked about, that attorney would face action from the state bar. So they're not going to do that. And he wanted to get that out in front. The second thing is he knew as well, just like it's happening right now, everyone knows about this case because he's pro se. If he didn't go pro se, just like Rory Wilson, did anybody hear about Rory Wilson's trial? Nobody heard about Rory Wilson's trial. You know why? Because they had that trial. They didn't videotape that trial. There were no cameras in that trial. Why would you have heard about Franklin Tucker's trial if he wasn't pro se? Why would any attention have been paid to this? Now, I know his wife was the CrossFit person, but trust me, they would have tried their darndest to make sure that nobody paid attention to this trial. So what Mr. Tucker was trying to do was he felt like this was a case that, due to the lack of evidence, due to the fact that this was going to be him, literally, and that's what this case comes down to, him versus Travis Johnson. He felt like, hey, you know what? If there were ever a case that a pro se defendant would take to bring to light all of the injustices here, this is what I'm doing. This is the one. And as a result, people paid attention. As a result, Court TV's paying attention. As a result, we all found it. As a result, I found this case because we're on it and we're reporting on it. As a result, people started to look at this case because up until he went pro se and he shows up and we hear about this crazy guy down in Florida defending himself against, the most serious charges you can face, no one cared. So that's why. Quinn didn't testify. Okay. Perry, that's a great question. And this is what I've been talking about. He didn't testify because, unfortunately, again, I think this was a byproduct of him going pro se. The state, it may not have even been a byproduct of him going pro se. I think what I'm going to tell you occurred, or at least what was garnered here from what came out in court on Monday, is essentially this. Mr. Tucker had to file a motion because Mr. O'Quinn is in jail right now. He's in prison. He's serving a sentence. As a result, you have to file transport paperwork, which has to get approved by the judge, and it has to be served at the facility that he's staying at. In this case, my understanding is that Mr. Tucker was unable to get the subpoena served on Mr. O'Quinn because the state of Florida, for reasons we don't know, began transferring Mr. O'Quinn all over the facilities all over Florida, including into one facility and put him in the pod with Rory Wilson. Rory Wilson is the individual that was Detroit that you heard about in this case. Now, eventually he was transferred out of there and I believe sent to another facility because obviously that creates a lot of concerns for Mr. O'Quinn. The question is, why would they have allowed that to happen? What were they hoping to happen if he gets in there with a guy who's convicted of killing another man in this case, having stabbed Mr. O'Quinn? How would the state of Florida have ever let that happen? How would the Department of Corrections ever let that happen unless it was intentional. You're not going to tell me they couldn't have known that those two are there on related charges, that he's the victim of Rory Wilson, that he was attacked in a case that Rory Wilson was convicted of essentially attacking him and cutting his pinky. So ultimately, again, this is what I talk about the ambush on Monday. Mr. Tucker finally was able over this past weekend to locate Mr. O'Quinn, and that's what he was telling the court. He served the subpoena. And he gets to court, of course, remember, he was under fire for being late and he needed to be on time. So he gets there on time and they have the morning session and he says, okay, Judge, I need a little guidance I need to file this motion and we need to get this served. And I've located where Mr. O'Quinn is and we could get him transferred down. And that was when the judge, go back and play it. And I guess I could find it here, but take my word and go back and play it. The judge essentially says, Mr. Tucker, he ain't going to make it here. You had to have that transfer order. It's got to get, I have to sign it. It's got to get served on him. And Mr. Tucker basically said, Your Honor, it's not my fault. And he said, I don't care. You're not going to get him here. There ain't no way he's going to get here by the end of the trial and I'm not delaying the trial. And he said, he's 5 hours away. If you sign it here, basically the judge is inferring the fact Mr. Tucker's on his own. Mr. Tucker can't drive it up there. Mr. Tucker doesn't have secretaries. Mr. Tucker doesn't have, the resources to expedite this up to the facility to get him down. And then they got to figure out how to travel him down. And he was just saying, there's going to be a lot of things that's got to be taken into account. But Mr. Tucker saying, I couldn't find him. Nobody knew where he was at. Because what happens is once they go in transit for purposes of the prisoner security, you don't know where he's at. He goes off the grid. And they kept doing that. So that's the answer, the long and short of it. As a result, that was part of why Mr. Tucker got frustrated on Monday, because once the judge said no O'Quinn, no LeVay, I'm going to rule that LeVay can't testify because of the fact that, number one, he's not here for us to talk to him about. But number two, there's issues of hearsay, there's issues of attorney-client privilege, and he's just not coming in, and I'm not having him testify, and he ruled. That was when the next day, the only two people they produced were from the Key West Police Department. That was what the state decided, hey, these are the ones we're going to let you have. And that was when Mr. Tucker decided, you know what? I don't need to have any of them. Fine. We're not putting them on. And decided to go ahead and rest his case and put it to the jury as it was, which, again, looking at this case, when you look at the jury instructions like we have today, I think it's going to be an okay outcome for him. But, juries have convicted on less, and that's a scary thing.
Some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, what the witness says about the defendant, testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of the other witnesses. It's entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not.
Now, I'm playing that because, and that'll be the last portion that we play here. That portion, again, I hope the jury was observant and listening, because being the fact that Mr. Tucker was an attorney in this case, as well as the defendant, okay, he was allowed to go, and again, this is the inappropriateness of Mr. Mansfield when he says, look at this defendant over there at the hospital with his tongue hanging out taking pictures. He was allowed to have contact with Paula. The judge even mentioned it a few times and said, yes, I understand normally, you wouldn't want to have the defendant having contact, but he was his own attorney. That was his witness. He's allowed to have contact with her. Now, one would say maybe taking that picture, might have been in bad taste just because of the fact that he's supposed to be there about business, but it was not a problem. It was not bad. It was not It was not something that was wrong. He was allowed to be there. But the state, again, another example where the state takes something like that was perfectly allowable and tries to twist it, tries to show it in a bad light to the jury and make it sound like this is, again, what they're talking about here, that this is proof of a mindset of guilt. This is proof that he has a guilty mind. And he's over here trying to interfere with this witness. Again, what I can't believe is that there wasn't something done to remedy the fact that the state was allowed to argue to the jury. I mean, I understand they're allowed some leeway, but there was no Facebook photos put in. There was no questioning put in about the trip. There was nothing at all proven in the case to suggest that whatever trip Paula took to California at whatever time she took it was paid for by Mr. Tucker's wife, or was in any way related to Mr. Tucker, except to say, well, she's poor, Mr. Tucker's wife is rich, therefore we have to assume that she must be getting some sort of favors. You know, it's a mystery to me. And yes, exactly. She was his friend, and like I said, I was not at all concerned about that. I didn't think it was a big deal, but I think it speaks to the lengths that the prosecution was willing to go in this case to try to make Mr. Tucker look bad. Now, Christine, you want to get back yesterday to yesterday's video on my channel. If you go back and you watch part 1, you'll see there's going to be a hearing where they're talking about instructions, and then following that, the state will go, and then right after the state goes, Mr. Tucker will come up for his closing. And again, I don't have the timestamps on it. If you go to Court TV, they actually have I believe they have his entire closing. If you search it up under Tyrone Tucker closing, they have his entire closing kind of cut out as its own separate video. So, and I do too. I would love to hear what the juror's perspective was on this. I hope Court TV or somebody gets a hold of a juror, and interviews them if they're willing to be interviewed, because it'd be very interesting to hear what the jury's take on this was, what they thought of him. And I'm sure if one of the jurors is amenable to it, they'll get him in an interview. But that's where we stand. So obviously, jury is deliberating, been out for about an hour and 15, I think going on an hour and 20 minutes now. And we'll see what they say. Hopefully, I think we're going to have a verdict by lunchtime, if not maybe after the lunch break. I don't think it's going to be too long. I think that's my opinion. Now, if somehow this case landed stronger than what we think, what I think, what many think, most of the time, I'll tell you, when I go in, I like to go in and look at the law and crime polls that they do in their chats. And I've been watching that for a long time. And most of the time, when you see more than 30% of the audience going either not guilty or hung jury, most of the time it comes back not guilty. That's a great indicator that reasonable doubt exists in the case and will exist with the jurors. And in this case, it's almost 50-50. And so I think that's a great sign that we're going to get a not guilty verdict. Doesn't mean it'll be, within an hour or two, but I think, because there is some procedural things that's got to happen when you're back there. So recovery addict as well. He's covering his case in as well. Oh, okay. I need to go over there. I'll have to check it out. But this is where I'm going to leave you. I'll come back when the verdict is back, when the jury's back, and we will go from there. And then I'll move on, of course, I'm going to keep putting things out. I mean, I'm going to keep talking about this case regardless of what the verdict is. Obviously, we're moving on to cover other trials that are going on as well. But there's a lot more to talk about, a lot more to put out, regardless of how the verdict goes, that people should be aware of, and should continue to look into things on this, because it's a very, very disturbing case when you look at it in its entirety and you figure out what they were really trying to get done here. And of course, we're going to get a conclusion today on whether or not the state of Florida was successful or not. Maybe it's not today, maybe tomorrow, but we're going to get a conclusion here. Tucker's wife and they just did a poll and it was 75% not guilty. Well, good. I'm glad to hear that, because And you're welcome. Thank you, G-Gen. That's it. That's great. I think, like I said, I mean, I will be shocked if a guilty verdict comes out of this. But again, it could happen. I mean, anything can happen. And juries can be, again, I guess the scariest point for me is normally when I'm watching a trial or analyzing a trial, right? I like to do it, to try to keep as little noise as possible out so I can know that, so that I can, have a clear mind like a juror would, and be able when I get to the end. And normally when I get to the end of watching a case, I can normally pretty much predict what we've got. Oh, good, 1,500. Okay, that's what I was wondering. So that's great, 1,500 people watching. So in this case, though, it's like I have a lot more stuff that this is kind of a unique case where there was a lot more available to consume, and that's all here now, right? So it's all being factored in when I'm looking at it. And to me, it's so clear cut, but I'm thinking, is it clear cut? Because if I was sitting in that box, inoculated from anything else, and not knowing anything else, and I'm just seeing that, would it be as easy for me as I think it would be? I believe it still would be. I mean, to me, when you look at this case and you apply the law, but who knows? I really truly believe he's not guilty. And when you look back at this case and you watch everything, and you've got to watch everything. I'm talking about watching the raw footage. And again, if you go to freefranklintucker.com and you watch the raw footage without any commentary, without any opinions, and you just go start watching, there's 66 videos over there. And you get to the end of this, you're going to see that, listen, he's guilty of one thing. He's guilty of cohabitating with people that were not obviously good people, right? Or we wouldn't say good people, but they were people that were going to get people in trouble. The second man is pretty clear to me. The second man was Travis Johnson. And I understand people are going to say, well, who was driving the truck? Who was driving the truck? If you get back and watch the trial, and I was watching Detective Malone's testimony and I'm reading through police reports. If you go back and watch the trial, okay, you're going to see, and even listen, you have to understand, not all of what Travis Johnson says is false, because a lot of what he says is from his own experience. But it's very key. Many people say, well, who drove the truck off? Listen, Travis Johnson himself tells you that truck was there the entire time of whatever happened in the Treehouse incident, because his testimony in court and the testimony of Detective Malone when they're watching the videos is that truck was still there. That first individual is running towards that truck. Now, some say, well, Todd O'Quinn ran. He didn't see a truck. He didn't see it. Well, listen, here's what we know. Travis Johnson says his truck was there. Todd O'Quinn never testified in court, but Todd O'Quinn gives statements. So Todd O'Quinn also missed a black sedan that was supposedly there by the 911 caller that was standing right next to him. So again, you have to understand eyewitness testimony. The experts will tell you 30 to 40% of eyewitness testimony is retained by the witness at the moment of the event that they're observing. It's why there can be such variance in what you're seeing. But what we have to look at is around what's going on, and you have to look at all the different statements and all the different things and the things we know. We know there's a truck in the video. We know that there's a second person running in that video. We know Travis Johnson has put himself there, whether it's inside the truck or inside the treehouse. My opinion is, without a doubt, it makes sense when you see the two guys, they pull up, they park. I mean, listen, Occam's razor. Simplest explanation is the easiest. He pulls up. He's there earlier, okay? He's out of money. He said he and not saying he wants to go after money. He wants to get high. He says, I want to get high. He shows up. He doesn't believe that they're going to go in there and murder anybody because Rory has told him, we're just going in. We're going to make it grab. We're going to grab the drugs. We're going to grab the money. It'll be a quick in and out. And he goes in, and this thing just, obviously breaks bad. He goes in, tells Todd O'Quinn, not Todd O'Quinn, Roger Ruggett, be quiet. Next thing you know, he's struggling with Roger Ruggett. He sees Rory over there. It goes bad. Rory's slicing the neck of Paula, and Travis flees. And you see him flee right towards the direction of the truck. He's going out towards the direction of the truck, and then the truck allegedly takes off, and Rory Wilson runs back. Why do you think you see Rory or Travis Johnson walking back towards the scene at 8:11 on the infamous video that's known as, I guess it's not the Tom Thumb video, but it's the video of Keys Electric? Because he knows he just left his dude there, right? Simplest explanation. He knows he just left his guy there. So he goes back, finds him. They walk back together, 8:15 to get back to the house. Who's out front trying to flee the scene? Who's out front freaking out? Which, again, the state didn't show this, but there's video, there's body cam footage that the police actually come in contact. They go over to the warehouse looking for Detroit at this warehouse, and they find Travis Johnson out front, getting ready to flee the scene. Well, guess what? He flees the scene, takes the book bag up to the location and hides it. So, again, it's simple. Travis Johnson. And Travis Johnson, when you watch him, if you watch the entirety of that interview, you see a man freaking out. You see a guy who says some honest things. I never intended to hurt anybody. I'm scared to death. I just want to go home and I don't want to go away for life. Okay. One of the things, and go back and watch the interview, one of the important things that Mr. Mansfield wanted to point out is he didn't understand, right? He didn't understand the rule that says if you're present at a robbery as a getaway driver, right, you're just as guilty of the murder, of the death, if a death occurs, felony murder rule, right? So why does he think he's going away for life? He said, I didn't understand that. I didn't think I'd get in trouble for that. But as a result, he's telling the police, that he doesn't want to go away for life. He thinks he's going to go away for life. Well, why would he think he's going away for life? Not, especially if prosecutor, according to Prosecutor Mansfield, Mr. Johnson didn't even understand that, hey, because I was present as a getaway driver because I'm sitting out front, I'm not guilty of anything. I drove off. Remember, at that moment when he's sitting in an interrogation room, he believes he pulled up, things go wrong, and he pulls off. So Mr. Johnson says, I didn't understand that. I don't understand the law. I thought I was completely innocent. No. When you watch that interrogation video, it's somebody who is freaking out because they believe they're going to go to prison. And as a result, he's freaking out. He's telling the investigators, I want to go home. I'm scared. And that's when Captain Phelps comes in and feeds him his lifeline. And you see it. If you watch that closely, you can see the entire process as he's sitting there realizing, and it had to be played for impeachment purposes in the trial, and there was a lot of distractions to it, and the state's objecting and doing all they can to try to keep it and from being able to be played in a way that the jury could really appreciate it. But he's sitting there, and it's like he's realizing, and she frames it to him. Listen, you're facing life. You're facing life. So here's the deal. You tell us what we want, and you get to go home. You're going to get the deal. Or continue telling us that Tucker's not involved. It's Tucker's life or your life. There was a trade made that day. Whether they'll successfully make that trade, we'll find out later today. But that was the trade-off. Because Phelps, again, prior to all the things that happened there, Phelps had already gone down a path where she believed Mr. Tucker was involved, only to find out that, guess what? The evidence didn't prove that. But the problem is, and one of the things that you can appreciate once you read through the picture deposition, is Miss Phelps didn't like being wrong. She didn't want to admit she was wrong. She surely wouldn't want to admit she was wrong to her subordinates. So for her, she's going to plow forward. And for her, as she said, they were just a bunch of crackheads and homeless people over there. They were the bad people. Tucker was the asshole. I think the most telling statement in the case is when she looks at Travis Johnson and says, who's the asshole? Not who's the killer. Not who's the one that did this. Who's the asshole? And she says, and he looks at her. He doesn't even say Tyrone. He says, he looks at her and throws a question back at her and says, Tyrone? And we can't see what she does. We can't see her face, but you can see that in the proffer as she leans across. And she's got a big presence. She leans across that table as she's talking to Travis. And she's talking to him in an affirmative, that like principle, that very commanding, like, you're in trouble, you tell me what you know way. But she's doing that in the interrogation room. We can't see what she's saying, but she's looking because they have that hat there. We don't even know. That's the other thing that I always thought was interesting, is his hat is positioned right in front of the body cam. Travis has said, well, we don't know what was in front of him. We don't know if a script was provided or what was there. We know, I think his notebook was open. I always found that interesting that the positioning of that hat was there. What was it hiding? What was behind it? But we'll never know. And that would be pure speculation. But bottom line is, she feeds it to him. She doesn't want to admit she's wrong. She thinks Tucker's an asshole, and she doesn't care because to him, he could have been involved. He might not have been involved, but she sure as hell isn't going to have her good friend Danielle Malone, whom she had a personal relationship with, and I'll leave it at that. Whatever the reason that she and Dunn were at the scene, there's obvious interest there in this case. We don't know what that is. And again, we don't have to know what that is. We don't have to know the why. The prosecution doesn't even have to prove a motive in a case. They can prove their case beyond a reasonable doubt with that by just simply having the evidence that it happened. And in this case, that's it. We could speculate on why it happened, but we don't have to say why it happened, because that's an impossible standard to meet. We don't have to consider that a cover-up happened. And the standard isn't, well, there's all this overwhelming evidence that a cover-up happened, except for one thing. We can't tell you why. Well, we can't tell you why because they haven't confessed to it yet. So it's just like if we said, hey, there's all this overwhelming evidence that someone committed a crime, but they haven't told you the why, so they should go home. I mean, it's a consideration, and because it's proof beyond a reasonable doubt, sometimes that could be considered a reasonable doubt. And then sometimes it isn't. Sometimes it's enough to say we have all of this evidence. We know he was there. We don't know why he was there, but that's not the standard. You can still say beyond a reasonable doubt, we believe this person did it. That's the proof. Did whatever it was they were accused of. So that shouldn't be the standard in considering whether or not this is a cover-up and whether or not there was a cover-up to this crime or whether or not this deserves to be looked into, because it's part of that investigation that hopefully might give us an explanation of what happened. But again, that's where we stand. So, but yes, Campbelltown, imagine if they got that interrogation. And again, the 3 minutes cut, there's so much that if they got, it's incredible. Well, you're right, Perry. And see, this is the thing that everybody needs to appreciate and understand. As I explained, a trial is supposed to be a presentation of facts and witnesses that can help explain what's going on. It's not supposed to be, let's conjure up, let's cut things out. It's supposed to be, we have an incident. Here's the evidence about that incident, all of the evidence, all the eyewitnesses, all the things that apply here. And when we take all of that into account, it proves beyond a reasonable doubt that the elements of the crimes were met. As a result, we have a guilty verdict. It's disturbing and concerning when we have witnesses that their only thing is, they're as credible, trust me, O'Quinn's as credible as Paula was. He's as credible as Roger Ruggett was. He's as credible as John Travis Johnson, okay? And I'm saying he's probably more credible, but I'm saying the issues that exist with all the witnesses I just named, O'Quinn existed with O'Quinn. There's no reason, besides the fact that the state did not like his testimony, that he should have been presented in this case and put forth before the jury so that the jury could consider what he had to say. The only reason he wasn't there is because he, from day one, very emphatically, and again, remember, if you go back to Malone's testimony, you see where on cross-examination, Mr. Tucker begins to get into the fact that not only did O'Quinn exonerate Tucker as being the second guy, the next day, when the police present him with a lineup he recognized John Travis Johnson in that lineup as being the second guy. That's who he pointed to as saying he couldn't definitively say, but he said he most likely looks like that guy. Now, the state didn't present that evidence because it wasn't evidence against Tyrone Tucker, and the way they presented it is well, he didn't name Tyrone Tucker, right? That's what she didn't hear him say that, so she could testify to that. But because O'Quinn never testified, the actual statements he made to her are not admissible because they're considered hearsay. Only if O'Quinn gets in the courtroom does that lineup become admissible. So they had a second reason, not just that he was running under. They wanted to keep out that because then you could put Malone back on the stand, which is why she was subject to recall, and you can play that body cam footage of the lineup of her pointing to Travis Johnson. Again, or not her, him pointing to Travis Johnson. And he could testify to that. And he could say that's exactly what happened. That's what I saw. Yes. He's allowed to bring that in. And that's allowed to come in. So, again, it's just, just unbelievable when you consider all the different things that were kept out of this case. Yeah, he's not. Recording this state was Tucker. I'm just getting caught up here on the Phillips picture. Yep. But yeah, Perry. Absolutely, he has no financial gain in this. There was not a financial gain. His sole purpose in doing this was because he hoped that he would be able to. First of all, he wanted attention to come down on the case, and two, he felt like he would have a better opportunity to attempt to try to get things towards the jury, at least talk about things in front of the jury that an attorney couldn't or wouldn't, for the simple fact they would be subject to potentially getting sanctioned by the state bar. And trust me, you saw how quickly Mansell, anytime it comes in. See, sidebar was used. He used a sidebar tactic because he didn't want Tucker to have the chance to get things out to the jury. So that's why immediately he would object and say sidebar. And then sidebar stops the proceeding, puts him up before the judge, and then they use the white noise so you can't hear what's being discussed at sidebar. So again, and again, you can't get too complaining about that because of the fact that technically speaking, some of these things were not supposed to technically come in, but it was just, he was attempting to take away the advantage that Tucker was trying to bring for himself, which was the ability to speak, openly in court and run with it, and kind of just say, hey, well, sorry, you didn't stop me from speaking quick enough. But no, to my knowledge, he's not divorced. And they were just on, if you go back and watch, it was an excellent interview between him and his wife. They were just on together, Vinnie Politan last night. So you go check it out. It's a great interview. Well, that's exactly right. And that's what I said. And the thing with Mr. Tucker, that's why I listen. I mean, listen, if there was ever going to be a moment where it was going to become apparent that he was guilty, it would have been when he took the stand. You need to understand, he wasn't planning to take the stand. He did zero prep. He had no, to my knowledge. In fact, it was the judge, and consider this, the judge was so convinced, it was so unexpected, the judge forgot to colloquy him. In other words, they forgot to go through the process because, of course, he was an attorney and the defendant, but there's a colloquy that he has to go through when he either decides to testify or not. The judge didn't even do that. The judge realized when Mr. Tucker brought up the fact that he was going to testify that they had rested his case, because remember, the judge rested his case for him. He didn't rest his case. The judge just said, well, I'm going to rest your case and we're going to move forward since you don't have any witnesses. And he forced the judge to do that. So the judge was so worried, about resting his case. He moves forward, rests his case, and then realizes I didn't even follow that. And that would have been a tremendous appellate issue because he wasn't colloquy, and every defendant has to have that happen. So the judge realizes, so we'll go back on Mr. Tucker, because again, had that all been done, and Mr. Tucker said no, the judge would have been able to block him from testifying. And it was the judge's mistake that landed him on the stand because they were not expecting that was going to happen. But anyways, the point of all of that is it was unexpected. And he gets on the stand and he tells his story and he gets subject to cross-examination, and it was unwavering. And the only thing that you can take from that cross-examination is you're going to try to misrepresent a statement that was made to him by a police officer at the time that he was believing Matt Bonnett was the guy that got killed and was the sole individual that was, that as they're talking about it, they're inferring that this is the knife that killed Matt Bonnett, and we have it, and it's going to have your DNA evidence on it, and we think you're guilty of murder, and that's the conversation. As a result, that's what he moves on with and takes from that conversation and says, oh yeah, that's what it is. And 10 hours later, he's having a conversation with Paula, and he infers to her or says to her something about the effect, yeah, they showed it to me, and they made it sound like it was Matt's blood on the knife. And then they say, that's the evidence. That shows he has a guilty mindset that only the murderer would have known, only the killer would have known at the house. I mean, really, And that's the other thing too. Yeah, that's exactly right. Who would have prepped him, himself? Well, no, now remember, Christine, he did have advisors that which were referred to in his case. Remember, do understand this, and this is something that's misunderstood. Some people misunderstood when I watch my shorts. And again, the full thing isn't able to be stated. But what I was stating was, if you go back and you watch, there was a hearing held back, I believe it was in September, right after the motion to dismiss. And what he had asked here, okay, and this is why people that were so upset with him about how he was acting and not knowing things and stuff like that weren't considering this. He filed a motion, which is entitled to, and in fact, this is something that's it's not uncommon that this happens. And there's been many other pro se defendants that have gone to trial in this exact light, and it's kind of almost preferred in a way because they want it helps make sure that it goes smooth and that the defendant is aware of the procedures. It's called a hybrid defense. It's where you can have a defense attorney in the courtroom. They're not of record. They either sit with you or behind you so that you can confer with them throughout the trial. So that way, what you saw happen in this case, where it looks like Tucker is disrupting the trial and he's not knowing what to do and the judge is yelling at him. Listen, the reason why I was so incensed with what happened here, okay, with the judge yelling at him and calling him incompetent, even though it was outside the presence of the jury, is because the judge himself set that up. Because Mr. Tucker asked for a hybrid defense, hybrid defense. In other words, he was going to be allowed to be the pro se attorney, speak to the jury, have his own attorney there who would be helping him with the procedure, so the judge wouldn't have to worry about that, who would be in real time available to explain to him motions, pleadings, procedures, and be able to give him that advice. But Mr. Tucker would be the mouthpiece. He would be the one giving the closings. He would be the one giving the openings. He would be the one questioning witnesses. But he would also be able to refer to his own counsel there that would help him craft questions and make sure he understood objections, help him object, help keep the interruptions down. And like I said, this happens. It's not an uncommon thing when pro se defendants are defending themselves that this gets asked for and granted. And Mr. Tucker asked for this, and the judge denied it. Why do you think the judge denied it? The judge denied it because they wanted to have this exact thing presented to the jury as it was. And they went out of their way. Mansfield was a jerk. The judge went out of his way to, make it clear to the public and the cameras and everybody, you've decided to go pro se. You're not prepared, Mr. Tucker. It's your fault. And the judge essentially set it up and said, nope, either go pro se all the way or let your attorneys handle it. Now, Obviously, he made the final decision on that. But the point of what I'm trying to say, when I say the judge didn't allow him to have an attorney, he did not allow him to have an attorney in the courtroom, and then turned around and used that fact against him. If the judge is so upset, he should have known that somebody who's got no legal training, hasn't spent time in law school, has never tried a case, that this is the exact result you're going to get. And that, judge, you need to be extra patient. You need to be extra lenient. You need to help them with things like making sure that you're securing the transfer of a witness, an important witness to the case, that you're helping make sure that subpoenas get renewed, that he should have been reminding Mr. Tucker, we've had a lot of delays. Have you renewed your subpoenas? And you would say, well, no, but those are procedural things that to make sure you preserve the case, to make sure this case is as fair as possible, to make sure that the disruptions are kept to a minimum, that those things are done. Instead, what happens? Mansfield basically says, I'm going to take advantage of this by doing as many things as I can. And several times in the case said, I'm not teaching Mr. Tucker the law. I'm not going to teach him procedure. I understand that, but you also shouldn't take advantage either knowingly and try to do something that's against procedure and try to get it in because Mr. Tucker doesn't know what procedure is. You're, as a member of the bar, you are supposed to be honest, and you're supposed to operate with ethics and integrity. Yes, I am. Right, and I understand. Again, every state is different, and every judge is different on what they do. But my point is that in that case, of course, the judge, that was an extreme case of just absolute craziness when Darrell Brooks represented himself, and it was a mess. But the judge in that case, of course, and again, I'd have to get back. I do not believe was making issue with the fact to the degree that this judge was. She was pretty fair, and she bent over backwards to the degree that she was almost brought to tears with some of the antics. But I think, in the case of Darrell Brooks, it was clear to everybody that this was a guy who was just, in my opinion, had a degree of mental problems, obviously, and was just a jerk and just really wanted to re-victimize everybody in that case. And that was the basis for him being his own defendant. The questioning was ridiculous, but I mean, in his basis was that, again, he was a sovereign citizen and that the court had no standing. So I think in his case, the motivation for what he was doing and the fact that he never had attorneys ever involved in the case at all, I feel like the circumstances were a bit different there. But like I said, the judge, obviously, I'm not saying the judge didn't have legal basis to make the ruling. He did. But I'm saying that when the judge was making a big deal about this to Mr. Tucker, he had a remedy for that. And Mr. Tucker had the ability to have an attorney in. One of the things I think in the Darrell Brooks case is Mr. Brooks himself, I don't believe was going to work well with standby counsel. And I thought, I could be wrong, I didn't follow that case that close because I didn't really feel like it was an interesting and entertaining case. I didn't feel like it was a case that really was ever having a serious chance was going to go anything but guilty. And that the facts were undisputed in that case. It was like I said, it was great entertainment. But I don't recall if Mr. Brooks himself ever had attorneys of record that did any real serious work. I'm pretty certain he requested, his whole basis of defense was that the court didn't have standing. He was a sovereign citizen, and I believe he dismissed the attorneys. Is that correct, Christine? I thought he dismissed them because he felt that they were that they didn't have, that this court, basically, like I said, his whole defense was he's a sovereign citizen and the Constitution doesn't apply to him and this court doesn't apply for him. And he's essentially being held by a tribunal that does not have the power to hold him. That was his defense. It wasn't that they couldn't prove it. It was simply that you don't have standing to try me. And then, of course, his attorneys were not going to argue that, and he was upset with them, so he dismissed them. And I do believe he was having, I think it was clear in that case that he wasn't going to work well with whether he had actual counsel or hybrid counsel. It wasn't going to help him. But the point is, in this case, with that is that the judge had a remedy. And for the judge to have made a huge issue of this, he was asking for it. He was, he didn't have conflict with his attorneys in any way. This was a strategic move he made because what he wanted to be able to do was speak to the jury. And what the state didn't want, the state was scared of the fact that because of the fact that Mr. Tucker would have been or is the attorney of record technically, and the advising attorney would not be responsible for what Mr. Tucker said, they were concerned that how dangerous he really would have been if he would have had skilled counsel in there with him and then been able to speak on his own. And then, of course, he could have had someone questioning him and prepping him to testify. But a lot of the things that occurred in this case in regards to the witnesses that weren't able to be called might have gone differently. There were a few areas that Mr. Tucker would have absolutely raised issues quicker. There would have been records made. And that was the other thing, too. In this case, the appeal record is going to be difficult on appeal, because because of the fact that Mr. Tucker wasn't an experienced attorney. A lot of areas were missed. A lot of opportunities were missed because one of the things that you've got to do is you've got to make proffers throughout the case. You heard it in the Adelson case if you filed it. You hear it all the time. Mr. Ashbaum would essentially ask the judge if jury to leave the room, and he'd go on the record, and there'd be a 15-minute argument. And you'd think there was actually some sort of argument going on, but it really wasn't. The judge had already ruled. He was just making the argument for the record, putting facts on the record that the appellate court would need to understand, so that if the appellate court, when they're reviewing it, they could assess what was the impact of this going to be, what was the evidence we were asking, so that when they're making their review of the record, they could say, well, looking at that evidence, if that would have been considered, that could have made a difference. And then they can go back and make a decision on whether or not it should be reversed. But that's the that's just a side effect. I mean, those are things that, again, we're not no sympathies being given there. I mean, that was just how it was going to end up. But that's the thing. Is a lot of people are going to look at this case and say, "Oh, there's all these appellate issues. You could get it reversed for this, for that." There's not going to be as many appellate issues as people think. That's why Mansfield didn't push forward when he was trying to get the prior consistent statement in for Johnson, because they understand, and that Mr. Tucker understands as well, I think, that if he gets convicted here, chances of him ever getting this reversed on appeal are going to be very, 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 very unlikely, because there was not a lot of appeal record. Now, today, when he went on record about that statement that the prosecution put in and argued in their closing arguments, a record was made. The judge made a ruling. That's why the judge got so mad, because Mr. Tucker was actually, up until now, the record is pretty clear of issues that might cause an issue on appeal of reversible error, regardless of what casual observers might say, because it's not because things didn't happen it could be reversed. It's simply because a record wasn't made of them, and you can't say ineffective assistance of counsel because he chose to represent himself. So as a result, the state is pretty protected in the event that this verdict comes back against Mr. Tucker, but except for what Mr. Tucker did this morning. And there was a couple of other times he made the motion to continue based on the motion to disqualify, which was denied. So it wasn't quite done as an attorney would do it, but at least that issue is on record, and the motion to continue was denied. So, that's a partial issue, but this was a full issue that he could say, listen, they brought in evidence that, was not presented in court, that couldn't be presented in court, that had been excluded from the court, then turned around and argued it, and essentially violated Mr. Tucker's rights by saying, hey, we're going to exclude this evidence. We're not going to let you talk about it. We're not going to let you defend yourself against it. And then the prosecutor gets to come in and make the argument and say and again, and this is why the judge was so mad, because had Mr. Tucker never brought this up, it would have never been able, as egregious as it was. But the state didn't just refer to this evidence. They called it a smoking gun. So an appellate court now, and the judge knows it, that will be the saving grace of Mr. Tucker if this goes against him because of the statements that were made. The fact that they didn't just refer to it, they called it a smoking gun. And that tells you the importance that they put on it. And they didn't even properly present this evidence to court. So that's a pretty big issue. It's a pretty big issue. Well, yeah, I mean, and I agree with you, Perry. It is very troubling that Travis was able to walk free. And yeah, Mr. Tucker, listen, regardless of what people think, prison, jail is not easy on anyone. Okay. It's not easy on anyone. And regardless, many people go, oh, they have it easy. They have TV, they have food. No, listen, the biggest thing that you have to understand, and again, listen to the Adelson tapes. Listen to Charlie Adelson tell you that. To me, I listened to his tapes, and what I found most interesting is the fact that he talks about, there's the smells and the dirtiness but the worst part of prison isn't the potential for violence, although that's terrible. The potential to be victimized, that's terrible. But no, it's not that. It's the fact that your life is on hold, and you're just sitting there. You've got nowhere to go. You've got nothing to do. You've got nothing to do ever again. You've been taken out. You no longer change your clothes. You're in the same orange, whatever color it is, and you're just sitting there. And your family, your kids, your friends, everyone else is living their life. Everyone else is going about their business. And the mental toll that will take, and that's why when you listen to prisoners talk about it's called doing your time. You can't think about that. When you think about it, you go crazy. The mental toll it takes on you. So the idea that any of this would be easy on Mr. Tucker if he went in, especially imagine if you know you're innocent. If you know you're innocent like he does, and I believe he was innocent of this, and he's sitting there and realizes, my God, this is it. This is where I'm going to be. And yes, he took great risk here because he wanted to bring attention to this. And he was, I think, believing that this case was so weak that he could represent himself, have a victory. And if this happens and he does have the victory, yeah, many people are going to pay attention to this. Vinnie Politan and Law and Crime and heck, even the major media outlets are going to want to talk to Mr. Tucker because this is a guy who took on the Bubba system, as Mr. Mansfield called it, who took on corruption, and he won. One man in a courtroom against the power and the money and the resources of the state. Yeah, it's going to bring a lot of attention to this. People are going to be very interested in this to see, how did this happen? And he did that. That's the risk he took. So that's what his calculation was. He did this because he knew this was the only way attention. So imagine he goes in there and the attorneys make an argument in court, a technical argument about reasonable doubt. The case gets won. He goes home and this gets swept under the rug. No one's paying attention. And as you can see, if you go into the damn Law and Crime chat, you see many people are, they would have just looked at this. Guy got accused. He got lucky. He would have looked at somebody who just got a slick lawyer, paid for by his wife, rich wife, and he walked out on a technicality. Now, reframe it to what he did here. Whether you understand it or not, and listen, many of you may, I have a comment that just came through one of my videos. How much is his wife paying? No, nobody's paying me anything. Listen, I have no problem, and I want to be clear on this. When I say this statement, I have no problem affiliating with Mr. Tucker. I would have no problem being affiliated with Mr. Tucker. No problem at all. From what I've seen, I don't know the man personally at all, in any way, shape, or form. Okay? But I'm not in any way saying I don't want to be affiliated. I'm just telling you the truth of the matter is this, is that I came into this case knowing nothing. Last Monday, when I started watching opening statements, I knew nothing about this case. Nothing. I didn't even know it existed. Okay? So what I'm saying, what I'm speaking, is not coming from any affiliation with Mr. Tucker. So what I'm about to say right now, many are going to say, "Oh my God, I can say," but what many people are not understanding yet, and it will become clear. And when it becomes clear that this is what happened, because Mr. Tucker's been going through this for 6 years, what Mr. Tucker did, and if he ends up convicted and in prison, or he ends up acquitted, what you don't understand is this guy that everyone laughed at. He's a hero for the people. Okay, and he will, when the story gets written, I believe he will be written as this is a guy who stood up. And what he did here, while others are laughing at him and saying, yeah, he used drugs and he was down here, but what he did here, the magnitude of what he did, many will not understand unless you go in. And again, I only understand. I mean, I have reviewed a lot of stuff, and I have an understanding of things about the justice system and stuff from personal experience. From my dad was a well-renowned defense attorney, and I was able to, have an appreciation to be able to look at things and see this case. And I said, oh my God, when I start reading into this. But what he did here, the magnitude of what he did here, that everyone is losing is, yes, he could have had a slick attorney come in and get an acquittal for him. Absolutely, without a doubt. If an attorney tried this case, he's found not guilty. But he knew that if he did that, he would simply be serving himself. And the story would never be told. And it would never be paid attention to. But he showed up in court. He fired his attorney. He attempted to have an advisor there, and the judge said no. And he still showed up anyways. He was given a 2-year sentence or an opportunity to walk away with 2 years of probation. He said no. And he walked in that courtroom, and a guilty man who is guilty would never have walked in that courtroom under those circumstances. A guilty man takes a plea. That's Travis Johnson. A not guilty guy who knows that he's become victim of the system down there, because unfortunately this isn't an uncommon thing with how they've acted in this case, certain elements and certain things that were done. He knew the only way attention would ever be brought to this was if he walked in and got everybody's attention. And he has done so at the ultimate price, the price of his life. So as crazy as it sounds, and you can call me crazy, I don't care. I mean, look, I have no affiliation. And I only say that because I want to understand. I'm speaking this not from I ain't being paid by nobody. I'm not being, I have no interest in this case other than justice and other than getting out what I've learned. This is me 2 weeks of looking into this case. But at great personal cost, he has gone in. He's put his life on the line to do this because he feels it's important, because, as Mr. Tucker has said, he doesn't want this to happen to anyone else. And yes, Mr. Tucker's come in my comments. Yes, I reached out and I got access to different documents and things. And he was, right in there. We were chatting right on one of my previews. That was the first time. I mean, he's coming in and talking to me simply because I reached out and needed to get information. He was willing to talk, just like he's willing to talk to Vinny Politan, so he's willing to talk to everybody else, right? But he has told me and said, as he said right there, and if you go back and watch it, it was a video, I think, that was Mr. Tucker, or it says Tyrone Tucker is innocent, and then had the not guilty picture up. And he says it in there. He's doing this because he wants other people. He wants to make sure this doesn't happen to other people, and he knew this was the only way. And those around him said, his attorneys advised him, take this plea. It's a great plea. So, however you want to judge this man's character, because of what you think you know, or because of a picture you saw, you can be like those detectives. You can be like Miss Phelps. You can be like Prosecutor Mansfield, who apparently these guys down here in Monroe County, Facebook is their investigative technique. It's like WebMD. No, it will go again. He will go again. I don't listen. You don't go through what he just went through and you go take a plea. He will never take a plea. And maybe I stand wrong on that, but I just do not believe that for the reasons he took this, that he went to trial, I do not believe that he will ever take a plea. I do not believe that. And I don't have any basis for that. I don't have any knowledge of that, but I just do not believe, based on what I've seen, based on all the things that I've seen, I do not believe that he will ever take a plea. No, I do not believe that. Because the point of this, in fact, I think what he'll do is he has, advisors. I think he's going to secure Todd Quinn to come in. I think the state would be very scared of trying again. I think that at this point, the state might even dismiss the case depending on if it was like 11-1, 11 not guilty 1. The state has the right to not try the case, and they could walk away from it. I think they would do that because I think they would be very afraid of getting someone like Todd Quinn in, or getting someone like Seth LeVay to come in and allow that motion to suppress to be put before the jury. I think they would know that the gig is up and it's done. I think that there's going to be a lot of attention put on this if he walks away with a hung jury. Enough attention that he's going to be able to go right to the media, right, and talk. He's going to have a voice, and his voice is going to be credible. And he's got his site. Listen, almost everything has come from the site he put up. And if you go on there and you question the validity of those videos came directly from his discovery. They came directly from his discovery that he's put up on there. He's just been waiting for someone to find him. And when I found the channel last week, I think he had like 97 or something like that, 91 or 92, someone in the 90s, less than 100 people. Now this trial, I think he's almost got 300-400. Everybody should be over there subscribing to that channel, watching those videos if you want the truth. You don't need a documentary. You don't need anyone to do it for you. The whole thing's right there. Go right over there. Make your own conclusions. It's a unique situation. It's great. I mean, that's an available resource. And then on top of that, go to the Monroe County Clerk's office on their website, and there's 770 documents on there. Some of them are available because early on, prior to 2020, they weren't as big on uploading the electronic documents, but you can go see the entire case file. You can go see the suppression motions. You can go see Travis Johnson's suppression motions. You can go into Steve Rory Wilson's case. It's called Free Franklin Tucker. Just put @Free Franklin Tucker, and you're going to see a picture of Mr. Tucker, and then you're going to see a wealth of information. Head on over and get subscribed to it just so you have it in there. And he's posted some, he posts, the interrogation videos and things like that over there. You're going to see it all. You're going to see everything the state kept out. And then you need to make your voice known. You need to let the state of Florida know, Monroe County and everybody down there, in a very nice way that we're unhappy with what happened in this case. And there is no way that people are just going to walk away from this once you watch that, once you see that, you can't unsee what you've seen. But that's why it's so important for them to keep you from seeing it. Remember that. So go see. And I'm telling you my conclusions. I don't expect you to believe me because who am I, right? I'm just telling you what I saw, what I read. I'm asking you. I'm confidently telling you. You go over and read it. I'd love to hear what your perspective is. I'd love to hear more people talking about that channel or the information on the channel. It's a YouTube channel. Yes. Yep. It is. And it's if you type in the search when you're searching @Free FREE Franklin Tucker, that's it. And when you search that and it's all one word. Oh, I agree with that. I mean, Judge Duro, she had amazing patience, and she did an outstanding job handling it. Because, like I said, what she was dealing with there was having to deal with someone who continued to raise and wanted to his entire defense was standing. In other words, that they did not have standing, that this case did not have standing, that it was not allowed, essentially, that he was not to be subject to American courts, which is, not recognized as a defense. And she had to very patiently continue to deal with that, interruption after interruption after interruption. And like I said, I think to a degree he wanted to. he really wanted to disrupt things. I mean, that was his purpose. That was his purpose. In doing that. Let's see here. So what are we at here? I'm just checking to see. No verdict yet, obviously. But that's where we stand. So why weren't the police? Well, because see, you have to understand this, okay? And this is something to understand about the way trials work, right? An interview with police is considered hearsay, okay? And what hearsay is anything that's not coming out of a witness's mouth. So a police interview will come in if there is a reason for it to come in. In other words, you call the witness, they testify, and you can't just have, like, for instance, you can't have a witness come in and say, well, we're going to, the police statement is simply to capture the statement and be able to allow for the defense attorney or whoever the attorney is on the opposing side to say, okay, we've captured this statement. Now they're going to testify. And if there is a inconsistency, that is a hearsay exception that will allow the statement to be played for the court so the jury can consider the fact that they made that statement. When they made that statement, they said A. Today they're testifying to B, and the judge and this jury can consider that. What they're not allowed to do, and the judge is very clear on this, and this is what was happening, is you're not allowed to put prior consistent statements into the record, because what the court doesn't want to have happen is they don't want the jury to focus on the fact that they've told their story so many times. That's not how we judge credibility. They want the credibility of the statement to be judged as the facts being testified to by the witness. And that is the only focus. Because if you were to allow consistent statements in, a prosecutor could take somebody and say, this person's going to testify. In our whole case, in this case, it would almost have been done like this, right? John Travis Tucker testifies, and then they put on Detective Malone, and she testifies, and they play his statement. And then they go in and they call his friend, Johnny Jones. And Johnny Jones comes in and says, John Travis Tucker or John Travis Johnson told me this. And then they put on Lonnie Smith. And you have 6 or 7 people that heard him recite this story that was consistent. Well, the jury is only considering now the fact, well, he's told this story so many times. And it's like, that's not evidence. The evidence is the statement. Now, if someone makes a statement that isn't consistent, that now becomes something that the jury can consider. And now you can enter the statement in as evidence for consideration of the jury, and they play it for the jury and say, okay, this is what this person said and it was different. And now they can use that as a basis for determining the credibility of the statement and the credibility of, and again, that's why the judge instructs. Doesn't mean the whole statement is wrong. It might just be a portion of it. And they can say, hey, we believe 20% is not right, but 80% is right. And the jury's allowed to consider that. They're absolutely allowed to consider, or they can dismiss the whole thing and say, this individual is completely uncredible. They lied about it, all these different things, and we saw that. We're not going to consider it at all. I know, and it's a shocking thing. It really is that it made it to trial. But it made it to trial. See, Tiffany, it made it to trial because guess what? Was anybody hearing about this case beforehand? No. Was anybody paying attention to it beforehand? No. And remember, there was a civil case filed in this understand this, okay? There's a civil case that was filed by the lead investigator in this case. It was filed against the sheriff for wrongful termination, and then it was also filed against Mr. Tucker, his wife, and his attorney. And the basis for that was that they defamed her character because they were alleging in court that her investigation was improper and that she had improperly tried to influence witnesses and all this stuff. She attempted in the middle of a proceeding where Mr. Tucker is facing life, and he was simply putting up a valid defense to this, questioning the investigation. She tried to impede that by suing him and cost himself, his wife, and the attorney. But she was trying to create a conflict for his attorney to conflict the attorney out because she didn't like that attorney because that attorney was aggressively defending him and did a very good job defending him. And she tried to create a conflict by filing suit. Luckily, after 2 years, that's another reason why this took 6 years. For 2 years, they had to litigate that right alongside with a criminal proceeding, and it cost him a lot of money and a lot of resources to defend against that, to which a judge eventually issued what's called a summary judgment. It's where it doesn't go before a jury. It's where the case is so weak that the judge actually comes in, reviews the depositions, reviews the evidence, and says, there is not enough evidence in this case to take it to a jury. I'm going to rule for the jury that it's so weak. And they ruled in favor of Mr. Tucker and said essentially that there was no evidence of defamation of character. And in fact, found, like we've all found, that again, in this case, what was at hand was whether or not it was true that Phelps mishandled evidence and was improperly and did improper things in the investigation. This judge essentially found that she did. That was the reference, if you caught it last week, when the judge got so mad because they were talking about it, and he said, "Sir, this is not a civil case. I don't care what a civil judge found." That statement was made in court. There's a reason for that, because a judge, other than Judge Jones, who's been involved in this from the beginning, and I'll leave it at that, was referencing the fact that another member of the bar, or of his, another judge, a fellow coworker of his, had found that, yes, in fact, the investigator in this case had done some terrible things. And when she was trying to file, and that, what case do you know of? That would have been like, again, like Mark Furman filing a civil suit to try to prevent O.J. Simpson's attorneys from questioning the things that were done in that investigation. And Detective Van Adder say, you know what, you can't do that. That's insane. You can't do that. Those are valid questions that can be raised based on evidence or based on things that occurred and reports that occurred and things that they found out about. And, but these are the crazy things that have been done in this case. So, yeah. Okay, good. Were you able to find it? Franklin Tyrone Tucker, and choosing the channel search option. I'll show you. Hold on one moment here. All right, so I'm going to share my screen one more time here. Give me a moment. All right, so let me show you. That's what you need to put in if you're looking for his. If you're looking for the channel at Free Franklin Tucker, and then when you click search, I got to go into the screen here. It comes up right at the top at Free Franklin Tucker. He's now got 302 subscribers today on the channel. And once you click into it, there's the channel. Well, there's the channel, and that's what you're going to see. 161 videos. I knew it was 160 something videos. So there it is. I would recommend, while the jury's out, if you're not watching the Crumley case or any of the other cases that are going on, go in, start checking that out in your free time. If not, while you're waiting on the jury to deliberate, do it on your free time. You're going to see what everyone's talking about. You're going to be able to see firsthand how disturbing this case is and draw your own conclusions. At least that's my opinion. Yep. I agree, Tiffany. I agree. Well, I mean, that's the problem, Andrew, is that he doesn't understand. Again, he filed, I think he filed the motion he filed, was simply to make record of what was going on. I think to file prosecutorial misconduct would have required far more time for him to put something together like that than what he would have been capable to put together overnight. But, I mean, that would be a basis for a potential appeal when you look at it, because if you could find that a prosecutor knowingly violated procedure or the law and did that, any member of the bar has an obligation to be honest, ethical, and truthful. So If he can prove that, and but again, like I said, I'm not saying there's not appellate issues, but from the record itself, they did a pretty good job because he didn't raise it in protecting themselves. So, anyways, I'm going to call it there, guys. I will be back, obviously, when the verdict comes, and we'll go from there. So, I hope the jury gets it right. I believe, if my estimation's right, I think we'll have a verdict soon, I hope. But, I mean, like I said, you never can tell how a jury goes or a jury reacts. Anyways, so I'll be talking to you soon, and let justice prevail in the meantime, and we'll talk to you later.